Legal tools that work. The best protection happens before anyone needs care. When you plan early, you choose tools that fit your state, your taxes, and your timeline, and you avoid last-minute moves that backfire. Let's walk through the core options, where they shine, and the trade-offs you need to respect so you don't trigger the look back or invite recovery later. Start with the heavyweight, an irrevocable Medicaid Asset Protection Trust, often called a MAPT. Why use it? Because when it's drafted correctly and funded more than 5 years before you apply for long-term care Medicaid, the assets in it are typically off the eligibility balance sheet and, critically, outside the estate recovery reach in many states. You can usually keep the right to live in the home via occupancy rights, have the trust pay taxes and upkeep, and appoint a trusted child or professional as trustee. Done right, many MAPs are structured as grantor trusts, preserving a step up in basis at death, so heirs aren't punished with avoidable capital gains. The trade-offs are real. A MAPT is irrevocable, so you don't pull principal back for personal spending. And funding, it starts the 5-year look-back. If you're inside that window when you apply, you'll face a penalty period. That's why MAPs are for true pre-planning. Think 5+ years out, not 5 months out. If you're healthy enough and the horizon looks long, a MAPT can protect the home and other non-retirement assets while keeping daily controls separate from ownership. Now, the deed tools. In states that recognize enhanced life estate deeds, often called ladybird deeds, the owner keeps full control during life. Live there, sell, refinance, even change beneficiaries. The transfer completes at death, so it typically avoids the 5-year look-back, no present gift, and bypasses probate, which often blocks recovery in probate-only states. Precision matters. One wrong phrase can turn an enhanced life estate into a traditional life estate that surrenders control and may trigger penalties. Use local elder law counsel who knows the exact language title underwriters expect. If your state offers transfer on death (TOD) deeds for real estate, they can accomplish the same probate avoidance goal. TOD deeds are revocable, must be recorded before death, and pass the property directly to named beneficiaries. The landmines, strict statutory forms, recording requirements, and the need to list contingent beneficiaries so a predeceased primary doesn't bounce the home into probate. Also, in some expanded estate states, certain non-probate transfers may still be within recovery reach. Verify your state's scope before relying on TOD alone. Where do revocable living trusts fit? They're excellent for incapacity planning, privacy, and avoiding multi-state probate when properly funded. But in some states that use an expanded estate definition, assets in a revocable trust can still be reachable for recovery. So treat a revocable trust as an administration tool, not a guaranteed MERP shield, unless your state confirms otherwise. Here's a simple decision path you can use with your attorney. Are you likely 5 or more years from needing long-term care? Consider a MAPT for the home and other non-retirement assets, MAP tax treatment, trustee choice, and funding timing. Inside 5 years, but capacity is intact and your state recognizes ladybird deeds. Use a ladybird deed for the home and pair it with POD/TOD on accounts to keep assets off the probate conveyor belt. If your state uses TOD deeds, instead, confirm statutory language, add alternates, and record now. If you own property in multiple states, consider a revocable trust for probate control. Then fund the trust or beneficiaries with state-specific deeds. Confirm recovery reach for each jurisdiction. 2 critical cautions. First, DIY documents. Templates that aren't state-specific cause the most expensive mistakes I see. Accidentally creating a traditional life estate, failing to reserve full powers, or missing a recording requirement that kills the protection. Second, sale risk. Deed tools protect the title path at death. They don't protect sale proceeds during life. If downsizing is likely, timing is everything. Without a seasoned MAPT seasoned beyond 5 years, cash from a sale becomes countable and can derail eligibility. Let's translate this into a clean, 30-minute consult checklist you can bring to local counsel. Bring the current deed, mortgage info, property tax bill, homeowner's insurance declarations, a beneficiary list for all accounts, and a one-page asset path map that labels each item probate or non-probate today. Ask exactly 3 questions. Which deed tool keeps my home out of probate here without triggering the look back? If we're 5+ years out, how would a MERP affect taxes, basis, and control? How do we coordinate POD/TOD on every account so one stray asset doesn't force probate? Quick wins this week. Pull and read your recorded deed. Confirm who's on title and how. Create your asset path map and circle anything that still says will. If you're in a Lady Bird or TOD state, schedule a deed review and record the correct instrument with contingents. Then sweep beneficiaries, POD on bank accounts, TOD on brokerage, and, where allowed, vehicles, and confirm institutions actually updated their records. Finally, write down your likely timeline to care, years, not months, and decide whether a MERP conversation makes sense now or next review. Plan early if you can, but even late, the right tool, matched to your state and your timing, keeps the home off the probate conveyor belt. And out of reach. In crisis moves, what you can still do. If you're already in care or approval just landed, don't freeze. You still have moves that lower recovery risk and protect eligibility. The key is acting fast, clean, and in the right order, without triggering the 5-year look back or forcing probate later. Start by asking one question. If the owner died today, what forces probate? If the answer is the house under a standard deed, fix the path while capacity exists. In states that recognize enhanced life estate, Lady Bird deeds, record one with primary and contingent beneficiaries. If your state uses transfer on death deeds for real estate, record a valid TOD with alternates now. Both routes bypass probate at death, which often blocks recovery in probate-only states. Remember, these deeds protect the transfer at death, not sale proceeds during life. Next, stabilize eligibility without gifts. Convert countable cash into permissible, necessity-based expenses that also preserve the property. Pay current property taxes and homeowners insurance. Handle essential repairs that prevent damage, roof, leaks, HVAC safety, and keep utilities on to avoid burst pipes or code issues. Replace an unreliable vehicle with one reliable car if your state allows it as exempt. Prepay allowable funeral/burial arrangements as your state permits. Keep every receipt. Those same records can reduce a future claim as allowed estate and preservation costs. If family is providing real care, formalize it now. Create a written personal care agreement at fair market rates while the elder has capacity, log hours and tasks, and pay by check or ACH, not cash. This turns vague help into legitimate spend that avoids the look-back gift presumption, may help eligibility math, and in some states can reduce a recovery claim as verified caregiving. Do not backdate agreements. Paper trails win. Improvisation loses. Route non-home assets off the probate conveyor belt so a stray account doesn't reopen the door you just closed. Add payable on death to bank accounts, transfer on death to brokerage and, where allowed, vehicles, and update beneficiaries for life insurance and retirement accounts. Call each institution to confirm updates are recorded, get written confirmations or screenshots. In probate-only recovery states, this sweep matters as much as the deed. About the 5-year look-back, stop gifts immediately. No $1 transfers, no adding kids to title, no helping with cash without fair value documentation. If questionable transfers already happened, pull 60 months of statements, list dates, amounts, and recipients, and work with counsel to cure what you can. Returned funds can reduce or eliminate penalty periods. Where return isn't possible, document any fair value exchanges. Home repairs, caregiving, rent with invoices, contracts, and proof of payment. Without proof, Medicaid presumes a gift. Capacity determines your speed and options. If capacity is intact, verify the power of attorney explicitly authorizes beneficiary updates, TOD or Lady Bird deeds where legal, and handling estate recovery correspondence. Many generic POAs lack these powers. Update now. If capacity is gone, you may need guardianship or court approval. That's slower, so prioritize essentials, securing the home, preserving insurance, and preventing probate triggers. Here's a 72-hour triage that works. Day 1. Secure the house, locks, mail forwarding, verify insurance is active and correct, vacancy rules matter, set property tax autopay, and take date stamped. Condition photos, pull the recorded deed, and schedule a consult with local elder law counsel. Start a binder, Medicaid notices, approval letters, the deed, tax and insurance statements, utility accounts, maintenance log, and funeral arrangements. Day 2. Record the Lady Bird or TOD deed if your state allows and capacity permits. Add pod/TOD to accounts. Update life insurance and retirement beneficiaries. Request 5 years of bank statements if LUBAC issues exist. Day 3. Formalize caregiving agreements, start care logs, order a broker price opinion for eventual valuation, and create an expense ledger for insurances, taxes, utilities, lawn/pest, and essential repairs with receipt placeholders. 2 timing traps to avoid. First, December surprises. A late year transfer or sale can push income or valuation into a bad calendar year. If you're near any threshold, eligibility, taxes, or future hardship criteria, consider splitting actions across January when legal. Second, beneficiary gaps. If a named beneficiary predeceases the owner and no contingent is listed, that asset can fall into probate. Update contingents now on deeds, accounts, and policies. If a recovery notice arrives, don't panic. Calendar the response deadline immediately. Request an itemized statement of Medicaid paid amounts by date and category. Pull your binder and start 2 tracks in parallel. Exemptions, spouse, minor or disabled child, caregiver child, sibling occupancy, with proof, and hardship math with exhibits if needed. Submit on time with delivery confirmation. Silence kills good cases. Married couples should use spousal protections and coordinate title. The community spouse can often retain resources under your state's rules. Don't impoverish the healthy spouse or liquidate the home without a plan. Convert excess countable assets into exempt forms the spouse can keep, and route title outside probate with the right deed tool plus alternates. If downsizing is likely, map the timing carefully. Sale proceeds are countable unless protected by a seasoned trust. Quick don'ts to finish. Don't rely on a will. It routes probate. Don't add children to the deed. That can trigger look-back penalties and creditor exposure. Don't miss certified letters. Set mail monitoring and alerts. Don't assume a revocable trust is a shield in your state. Confirm recovery, reach first. You're late, not lost. Route the home off probate, where allowed. Preserve eligibility with lawful conversions, formalize caregiving, sweep beneficiaries, and build that binder. Speed plus clean paperwork turns crisis into control. The money math, claims, equity, and what survives. Let's make the numbers do the talking, because once you see the ledger, smart choices feel obvious. Medicaid can't recover more than 2 limits: what the program actually paid for covered long-term services and supports after age 55, plus related hospital and prescription drugs tied to that care, and what it can legally reach, often the probate estate in probate-only states. Your job is to shrink that reachable pot, or better yet, keep the house off the probate belt altogether, so its math never enters the equation. Start with a simple framework: paid versus pot. On one side, request the itemized Medicaid paid ledger by date and category. On the other, calculate the net probate estate after allowed deductions. Recovery equals the lesser of the paid ledger or the net pot the claim can touch. If either side goes down, the recoverable amount goes down. Now, what reduces the pot? Allowed, well-documented deductions and priority costs. Think reasonable funeral and burial expenses, court filing and publication fees, personal representative and attorney fees, property insurance, property taxes, essential utilities, lawn/pest for preservation, and necessary repairs to prevent damage or close a sale, roof patches, leak remediation, safety fixes. Key rule: if you can't prove it with receipts, statements, and a clean ledger, it rarely counts. Build that ledger early, not in panic. Let's run crisp examples. Example A. House with mortgage and deductions. Clear calculation. Mom's home sells for $500,000. Mortgage payoff: $110,000 realtor commission plus closing costs, $30,000 net after mortgage and sale costs, $360,000 deductions from estate, allowed funeral, $12,000 estate administration, $9,000 insurance, taxes, utilities, $4,500 essential repairs, $3,500 net estate after deductions, $331,000 Medicaid paid ledger, $240,000 recoverable amount equals lesser of $331,000 net estate, or $240,000 paid equals $240,000 heirs receive, $91,000. Example B. Same house, higher paid ledger, lesser of. Still controls. Same net estate after deductions. $331,000 Medicaid paid ledger. $168,000 recoverable amount equals lesser of $331,000, or $168,000 equals $168,000 heirs receive. $163,000 mortgages matter because they're senior liens. If the house sells for $500,000 and the payoff is $250,000, you don't have a $500,000 recovery. Base: you have proceeds after that debt and closing costs. Always attach the payoff statement and the final closing disclosure. Clean documentation tightens the math and prevents inflated assumptions. Valuation is another lever. Don't rely on a stale tax assessment. Order a broker price opinion or appraisal pegged to date of death. If condition drags, value, document, as is photos and estimates. Lower fair market value when accurate yields lower net estate after ordinary costs. The goal isn't to deflate, it's to reflect reality with third-party evidence. What about liens versus claims? In most age 55+ long-term care cases, families don't see a pre-death lien on a protected homestead. They see a post-death probate claim. That order matters because mortgages and sale costs come off first, administration and necessary preservation next, and the recovery claim sits in the stack like an ordinary creditor with statutory priority. You're not guessing what gets paid before what. The process dictates it. Use that to your advantage with receipts and timelines. Now, the hidden superpower: path beats math. If you used a properly drafted and recorded enhanced life estate, Lady Bird, deed in a recognizing state, or a valid transfer on death deed, recorded before death in a probate-only state, the house often bypasses probate entirely. In that case, the home isn't in the reachable pot, so its equity isn't part of the recovery calculation at all. The number for the house drops to zero because there's no probate value to touch. That's why routing around probate is more than legal theory. It rewrites the ledger. 2 edge factors can also help. First, cost-effectiveness thresholds. Some states won't pursue tiny net estates or minimal claims because collection costs exceed recovery. Don't count on that for a high-equity home, but if the estate is small or underwater after debts, ask whether your state's manual lists low-value exceptions. Second, hardship waivers modify the claim based on documented impact. They don't change what Medicaid paid. They reduce or waive what's recoverable due to your numbers. When granted, they lower the claim column, not the valuation column. Here's your quick worksheet. Medicaid paid ledger. Request itemized by date, category, and post-5/5 total. Estate inventory. List probate assets only. Identify non-probate to avoid mixing apples and oranges. Valuation. Attach a BPO or appraisal. Include mortgage payoff and closing disclosures. Deductions ledger. Funeral, admin, insurance, taxes, utilities, preservation repairs, each with receipts and bank proof. Net estate after deductions, the pot the claim can actually reach. Compare. Recovery equals the lesser of net pot or paid ledger. Common mistakes that cost real dollars, missing receipts or paying cash. No paper equals no deduction. Over-optimistic market value without third-party support. Forgetting admin and preservation expenses the estate already paid. Mixing non-probate assets into the probate pot, inflating the target, ignoring mortgage payoff timing, and relying on estimates instead of final statements. Bottom line, do the math, document the math. And best of all, change the math with the right title path. Keep the house out of probate where allowed, and it drops out of the recoverable pool. If probate is unavoidable, tighten the net with accurate valuation and every allowed deduction. The numbers are neutral. If you feed them proof, they'll often leave more for your family than fear suggests. The sneaky mistakes that trigger recovery. Let's turn this into traps you can actually avoid. These are the quiet moves that hand your home to recovery on a silver platter, plus the clean fixes that shut the door. Mistake 1, relying on a will. A will instructs probate. It doesn't avoid it. When the house rides the probate conveyor belt, the recovery claim has a lane. Fix, use a state-recognized enhanced life estate, Ladybird, deed where available or a statutory transfer on death, TOD, deed recorded before death with primary and contingent beneficiaries. Mistake 2, adding a child to the deed to be safe. That's often a present gift, can trigger the 5-year look-back and exposes your home to your child's creditors, divorce, and lawsuits. It can also mess up step-up in basis at death. Fix, use beneficiary-style transfers that complete at death, Ladybird or TOD deeds, so there's no present gift and no creditor exposure from your child during life. Mistake 3, using a traditional life estate by accident. One wrong phrase can surrender control and create a penalized gift if made inside the look-back.